Thank you everybody for joining us for the third week of our Bankruptcy Help Desk Volunteer Attorney Training webinar series. As you come in, remember to mute yourself and go off screen to help with bandwidth. And then you can check the chat for a link to the plan. And as time goes on, you'll see links to CLE information and the survey and such. So today we have a focus on Chapter 13, in particular on the Chapter 13 plan, which is of course the unique part of Chapter 13 as compared to 7, and that which many of us often have the most questions about. And certainly at the help desk, it is easily the most challenging part of working with debtors. And so we're very glad to have an expert on the Chapter 13 plan here to share her experience and wisdom and expertise with us, Yannick Polycarp, who was in private practice for a number of years until a couple of years ago when she became employed by the standing Chapter 13 trustee, Marilyn Marshall. And so she's been in that role for a couple of years, and many of us have worked with her. And we're very glad to have her here to take us through the plan with an eye toward issues, again, that come up for debtors, for pro se debtors, to help us do our job better at the help desk. So without further ado, thank you. And I'll turn it over to you, Yannick.
Thank you, Dan. Hello, everyone. My name is Yannick Polycarp, and as Dan said, I'm a staff attorney with the Chapter 13 trustee, Marilyn Marshall. I've been a staff attorney for about 2 years right now. And before that, I was in private practice. I was a debtor's attorney. I was a creditor's attorney. I've been a jack of all trades in bankruptcy. The purpose of this presentation is specifically to assist pro se debtors who come in to the help desk, who need help either preparing or amending their Chapter 13 plans. Quite often when a pro se files a Chapter 13 plan, the plan is predominantly blank. They don't have all the creditors filled in. They don't have the plan payment amount or percentages calculated. And a lot of times when I do a 341 meeting, a pro se will think, well, I've come to my trustee meeting and that's when I'm supposed to be told what goes where. And that's not the case. The debtor needs to propose a plan for the trustee to review. So I broke it down into 4 sections. First, a brief overview of Chapter 13 and the role of the trustee. Then we're going to go over the basics of each section of the plan in the order it appears in the plan in Part 2. In Part 3, I've labeled it Order of Operations because a plan should not be prepared from top to bottom. There are certain sections that need to be reviewed and filled in before others. So I've labeled that the Order of Operations. And then Part 4 is just in general, how to complete a plan. So first, the role of the Chapter 13 trustee. Basically, the role of the trustee and the staff attorney of the trustee is to make sure that the proposed Chapter 13 plan will work to pay creditors. Chapter 13 trustee's office cannot give legal advice, cannot assist the debtor with filling out their plan. All we can do is raise objections and hope that they can complete the plan or seek assistance from the help desk to complete it. In order to confirm a plan, it must comply with Section 1322 and 1325 of the Bankruptcy Code. And the basic requirements of those sections are that the plan proposed by the debtor pay all available disposable income. And hopefully you saw Kathy Stagey's great presentation last week on schedules and how to prepare and fill out schedules. So we're talking about available disposable income. That is what is left over on Schedule I and J that's available to pay to creditors. We also want to make sure that the plan is proposed for the correct term. Most pro se debtors are under median in that their income is below the median income for the state of Illinois. And I think preparing the 122C1 and 2 forms and deciding whether they're above or below median was also in a prior presentation. And that's a document that the debtor should already have prepared. But most pro ses are below median, and so they are required to have a minimum 36-month plan. So we want to make sure that the plan is proposed for the correct term. We want to make sure that all documents have been satisfied. The trustee wants to make sure that tax returns and pay advices have been tendered, and also that the plan is proposed in good faith. And good faith is a broad title for a number of things that the trustee may look at in terms of fairness to creditors, fairness of the plan that's proposed. So that is basically the role of the Chapter 13 trustee, not to prepare the plan or propose any plan terms, but just to make sure it complies with the code. Generally speaking, when you sit down with a person who asks you for help to fill out a Chapter 13 plan, I think first and foremost, it's important that you find out the purpose or the motivation for filing the Chapter 13. What is most important to the debtor that you're sitting with? Is it to cure mortgage arrears? Or are they filing Chapter 13 because they're delinquent on their car payments and they want to either prevent repossession or get their car back from a creditor? Or even if the car has been repossessed, booted, or towed by the city of Chicago. And what their motivation is will really prompt what you focus on first when preparing a Chapter 13 plan. And, to a certain extent, when you're looking at their documents and what their motivations are, also try to make a determination as to, is the Chapter 13 the best route for the debtor? Is the plan the best route for the debtor? Should they be committed to making payments for 36 months if there is no secured debt, if they don't have a lot of excess income to put into a plan? Maybe also advise them on Chapter 7 as an option if it doesn't look like a Chapter 13 is necessary. There is a purpose behind each section of the plan. And one of the biggest issues we see at the trustee's office with pro se plans is that and debtors attorneys too, they don't fill out every section of the plan. Every section has a purpose. Every section has a box that needs to be checked. Each and every section of the plan must be completed, even if the debtor believes the question or section doesn't apply to them. So as we go through the sections, you should also go through each and every section with any pro se debtor that you meet with. And for example, you can have a situation where as you're going through each and every section, you may not think they own real estate, but when you ask them about it, they'll say, oh, I just didn't include that in my plan. Now, everything's got to be in each and every section of the plan. So my strategy for this presentation is to review the plan top to bottom, starting with Section 1, ending with Section 8. And my note at the bottom of the page, top to bottom is not the best way to tackle completing a plan. Sometimes you need to start in the middle, and we'll get to that in part 3 when we discuss what is essentially the order of operations and what needs to be filled out first in order to end up with a complete, thorough, and feasible Chapter 13 plan. So starting with the top of the form, and there should be a link in the chat that you can copy and paste if you want a copy of a complete plan to follow along, but I did cut and paste sections of the plan on each slide as we discuss them. But top of the form, put the name of the debtor or both debtors if it's a joint case. Oopsie, sorry. Right here, first name, middle name, last name. If you are filing an amended plan, you have to include the case number that has already been assigned to the debtor. And also this box right here off to the side where it says, check if this is an amended plan and list below the sections of the plan that have been changed. So this is kind of what I mean by the order of operations. That's at the very top of the plan, but it's the very last thing you fill out because the court requires that you list every section. If you're filing an amended plan for a pro se that already brought a plan to court, you need to list each and every section that you made a change in. It helps the trustee compare the two plans, and it also helps the court and the judges review the two plans to see what has changed and what impact it has on creditors. This part, the Section 1, it's also at the top, but needs to be done near the end. And it's often overlooked by both pro se's and attorneys. The purpose of this section is notice. It is for notice to all parties. And when they drafted the national plan, they put this notice section in because they wanted secured creditors to be alerted from the very beginning that there is something in this plan that affects you. There's something in this plan that modifies your rights. So for each line, you must check one box, either included or not included within the plan. Failure to check a box can render the section ineffective. So if you've included something in the plan, but you don't check the box that says it's included, it will be ineffective. So 1.1, if you're limiting the amount of a secured claim later in the plan, which we'll get to, if you're making a partial payment to a creditor, gotta check the box. If you don't check the box, the trustee is gonna pay the whole claim because it's not effective unless you check included. Avoidance of judicial liens. If you're including that in the plan, got to check the box. And also non-standard provisions in Part 8. And a lot of time people will put non-standard provisions in Part 8 and forget to check that box, which will make it ineffective. Section 2 of the plan, I called it how much and for how long. In this section, you have to put how much the debtor has available to make their monthly payments. So if Schedule I and J has $200 a month available, and that's all the debtor needs to complete a plan, that's what goes here. How much and per time frame. Every trustee wants the payments to be monthly. So whatever it is, $100, $500, it has to be per month. Sometimes you'll see plans that are set up biweekly because the debtor gets paid biweekly. It's incredibly difficult for the trustee to administer. So we ask that all plans say per month and then for a number of months. Like I said earlier, most plans, it's a minimum 36 months. So that's the number that's usually going to go there, unless your debtor is over median based on the 122C 1 and 2 form that has already been filled out and discussed in a prior CLA. So how long is determined by the 122C 1 form and necessity. If you've got a huge mortgage arrears and it's not going to get cured in 36 months, you may need to put some more months in the plan, but it is a minimum 36 months. And there's this second section that's in a bracket. It allows for payments to step up when necessary and when money may be available later. Like, for example, the debtor is currently paying a 401k loan, but it's going to end in a year, and they're going to have another $150 a month available in that year. You can provide for that future additional payment here. So it could be $100 for 12 months and then step up to $250 for the last 24 months if it's available. The rest of section 2, is there any other money available besides the monthly plan payments? Section 2.2 needs to be checked. A box always needs to be checked in every section as to how the debtor is going to be making their plan payments. Will they be making it pursuant to payroll deduction, which means having their plan payments deducted directly from their paycheck via their employer, and they would need to submit a payroll control order. Or the debtor can check a box that they will make their payment directly to the trustee, and that would just obligate them to make their payment by mail or online every 30 days. Section 2.3, also need to pick a box. And the options are what is going to happen to this pro se debtor's tax refunds. A lot of times with people with multiple children and lower income, they may get very large tax refunds. And the trustee provides that you can either tender your tax refunds every year and keep the first $1,200, or when the schedules were prepared, if the schedules provide for the tax refunds as income, which means dividing it up prorating it on the Schedule I, so that, say, I'm going to pick a big number for easy math, say a person anticipates getting a $12,000 tax refund every year. You can put on Schedule I, anticipated tax refund of $1,000 a month. And that way you can pick the second box, which is that you just have to provide the trustee with a copy of your income tax return. And that's prorating. Tom Vaughn's office very much prefers that people prorate. Our office, either way is fine, either prorating or turning over your tax refunds. But you have to pick. Either they're prorating their tax refund on Schedule I, or they're turning it over to the trustee every year, less the first $1,200. And the first $1,200 thing is an agreement that was made amongst the Northern District trustees. And we each have standard language on our website that you can put right here. Check this third box and just put the standard trustee language in here that will allow the debtor to keep that first $1,200. So when filling out section 2.3, please be sure to refer to the trustee website. You can just copy and paste that language right in there, and it will work fine. Section 2.4, additional payments. Additional payments are any other money that the debtor anticipates receiving during the term of the plan. Most often I see it used for personal injury lawsuits, where the debtor is only able to exempt the first $15,000 of the lawsuit proceeds on their Schedule C when they disclosed it as an asset. So they're going to have to check a box here and state that, say, any non-exempt personal injury lawsuit proceeds shall be tendered to the trustee. Or what else? If they're anticipating an inheritance, or if they get an annual bonus from their job that doesn't fit into the budget, that's something that you would put in section 2.4 as additional payments to the trustee from other sources as specified below. Okay. Part 3 of the Chapter 13 plan is, I would say, the trickiest part of the plan. Part 3 is the treatment of secured creditors, and you have to decide which section each creditor belongs in. So your options are, you have section 3.1, which is to cure and maintain long-term secured debt. Long-term secured debt, meaning debts that extend beyond the term of the plan. An example is a mortgage. You have a 30-year mortgage, and you're certainly not going to try and pay that in a 3-year plan, but you want to cure the arrears. That is cure and maintain. You're just going to cure the default during the plan and maintain your regular contractual payments for the life of the debt. It is for loans that exceed the term of the plan. Rare cases, and I've seen it more and more lately, car notes. A lot of people are financing cars for like 72, 75, 80 months. So if the debtor has financed the vehicle right before the case is filed, and the term of that vehicle is going to extend beyond the plan, and they love their contract rate, they got like a 0% interest rate, and they want to keep that car note as is, that can go in 3.1 if it is a long-term debt. And we'll get to the specifics of 3.1 in a second. Another option is section 3.2 for claims secured by the value of the collateral. So that's for claims that you want to cram down because the debtor owes way more than the collateral is worth. So for example, I owe $12,000 on a car worth only $6,000. You can provide for the plan to pay only the secured claim of $6,000, only the value of the collateral, unless the claim belongs in section 3.3. And 3.3 is secured claims that must be paid in full pursuant to the code. 3.1 is only for purchase money security interest that was incurred within 1 year of filing. So the debtor financed the purchase of an item of value within 1 year of filing, or purchase money security interest in a motor vehicle purchased within 910 days. So when you hear people referring to a 910 claim, that's what they're talking about. Cars that were filed within 910 days, or cars that were bought within 910 days of filing. Those claims must be paid in full. Then you have section 3.4, which is lien avoidance, which is where you would put judicial liens on collateral that has no equity to support the judicial lien. So you're stripping a lien off. That would go in section 3.4. Or if the debtor just wants to surrender the collateral, that goes in section 3.5. So let's look at each section individually. Starting with 3.1, long-term debt. And again, every section has a box that needs to be checked. So if the debtor has no long-term debt, please check none. If they do have a debt that they want to cure and maintain, where the contractual payments are maintained, they need to fill out this section. And it needs to read, it reads kind of like a sentence. Who's the creditor? Say City Mortgage. Well, what collateral do they have a lien on? It could be a property address, it could be a vehicle, but describe the collateral. Don't just put house, like put 224 South Michigan or the address of the collateral. Now, this is the cure and maintain section. So if there are current monthly installments that need to be paid, so you want to put the monthly payment of the contract here, and then who is making the payment? And a lot of times pro se debtors don't realize it's their choice. Who is making the installment payment? Is it the trustee or is it the debtor? Most oftentimes it's the debtor, especially with a mortgage payment. All the Northern District trustees have a trustee fee for funds that they've dispersed. So when you put a mortgage there, it costs the debtor more essentially. So more often than not, you're going to check the debtor box, but you have to check one. Who is making the current installments? The amount of the arrearage. So if they're behind in their mortgage, the arrearage amount goes here. You want to look on the claims register to see if the mortgage company has filed a proof of claim. If not, the debtor can put their best estimate as to the amount of the arrearage. But note, when you read the language of section 3.1, any existing arrearage on a listed claim will be paid in full by the trustee. So, unless otherwise ordered by court, a proof of claim filed before the claims bar date controls over any contrary amount that the debtor may put in here for arrearage. So someone may think they're only $1,000 behind on their mortgage and they're actually $10,000 behind. If the mortgage company files a claim for a $10,000 arrearage, that's what the trustee is going to pay. I also recently had a conversation with a debtor's attorney who called and tried to say the trustee was paying the car wrong because we were dispersing to this car creditor. But he put them in 3.1 and there were arrears in the car claim. And 3.1 says the trustee will always pay the arrears. So name of the creditor, collateral description, who's making the installments, best guess as to the amount of the arrearage, monthly plan payment on the arrearage. You can divide up a portion of the plan payment to be designated to the arrears, and then the estimated total payments to be made by the trustee. And this is estimated, so it doesn't control. What controls is the amount of the arrearage, either in this line or in the proof of claim. But you should complete every line. And this section is not for secured debts to be satisfied during the plan. If you put a secured debt in here and you have the trustee making monthly payments, the trustee is going to keep paying it for the life of the plan. And you don't want that. I mean, if it pays off in 18 months, why would we keep making the payment? Reviewing section 3.2 for secured claims that are secured by value. Again, if there's none, please check the none box. And note that there is a reference to part 1 here, and it specifically says the remainder of this paragraph will be effective only if the applicable box in part 1 of this plan is checked. So remember at the top when I said fill that part in last, If you cram down a secured creditor in this section and you don't check the box, it's ineffective and the claim will be paid in full and it will cost the debtor more money than necessary. So make sure you're checking all your boxes. You want to fill in each section completely. Again, with the name of the creditor, an estimated amount of the creditor's total claim. People don't always know exactly how much they owe on a car or exactly how much they owe on that furniture they financed, but it needs to be a fair estimated amount so that we can determine if the plan is feasible. An accurate description of the collateral, keep doing that. An accurate description of the collateral, as in household goods, a car, if it's a car, put the year, make, and model of the car, as accurate a description as you can of the collateral. The value of the collateral. Now in section 3.2, we're trying to say that the collateral is only secured by the value. So the value of the collateral is what the debtor has already put in their schedules. In Schedule B, that 2015 Toyota Prius that's worth $5,000. That is the value of the collateral that goes here. Amount of claims senior to the creditor's claim. If you're dealing with collateral that has more than one lien and there's a senior lien, you want to put the amount of the senior lien there. The next section will be the amount of the secured claim that you're proposing that the creditor receive in the course of the Chapter 13 plan. The amount of the secured claim usually matches the value of the collateral unless there's a senior claim that cuts into the value a little bit. Interest rate. Most creditors will object if you don't provide them with an interest rate in section 3.2 of the plan. You don't have to provide them with their contractual interest rate, but you have to provide them with an interest rate pursuant to, there's a case in Ray Till that says creditors deserve market rate plus an extra 1 or 2% interest for the risk factor. So most creditors will let a debtor know what the standard till rate is. I think right now it's about 5% that cars are looking for. And it's a double-edged sword because if someone's financing a car at 19%, it's great. You can reduce the percentage to what's a fair amount under till. If they financed a car under 0%, it's not so great because they still have to pay the interest rate as provided by till. So you want to be aware of that. Monthly payments to the creditor. You must provide a set payment to creditors in section 3.2. It needs to be a fair monthly payment. It has to be a feasible monthly payment so that the claim can get paid in full over the life of the plan. And we usually prefer equal monthly payments for the monthly payments to the creditors. And then the estimated total. Again, the estimated total doesn't control, but you do want to complete the entire math equation and do the sentence, amortize with the interest, because it will help you determine if the plan is feasible or not, if you have a number to use for the estimated total number of payments. And also section 3.2 very specifically says right up here that it does not apply to secured claims for governmental units. It says for each non-governmental secured claim listed below, section 3.2 controls. For secured claims of government units, unless otherwise ordered by court, the value of the secured claim listed in the proof of claim controls. So if you put the city of Chicago in here and try and strip off a city of Chicago lien, it's ineffective because 3.2 specifically says you need order of court. So a motion to modify or a motion to value the secured claim, something like that. If you put a government unit in 3.2, their claim controls absent court order. Section 3.3, I call it too new to modify. If they just bought something, the plan does not allow them to modify the secured claim. It doesn't allow a debtor to cram down to value. We all know that as soon as you drive a car off the lot, the value goes down. But if you've bought that car within 910 days of filing the bankruptcy petition, you need to pay the car creditor's claim in full. I know, like on our system, we just have like a little calculator, and if you click a button, it automatically tells you what date was 910 days ago. Something you can find on Google, stuff like that. So if a car was bought within 910 days, name of the creditor, again, the collateral description, year, make, and model if it's a vehicle, the amount of the claim, best estimate by the pro se debtor, because of course, whatever claim the secured creditor files will control, interest rate. So you have to pay the claim in full. You don't have to pay the claim's interest rate in full. The interest rate is still controlled by TIL. It is still a fair interest rate based on the market value plus risk. So if you've got a 910 car with 22% interest, you do not have to put 22% interest in section 3.3. Put a fair interest rate. If the creditor objects, they object, but you're not required to pay the full contract interest. Monthly payment, important, a set payment for that claim. Is it to be dispersed by the trustee or the debtor? And then the estimated total payments by the trustee. And again, these claims will be paid in full. And if there's none, check none. And yeah, I should point out, a timely filed claim controls. So no matter what amount you put for the amount of the claim, if the creditor files a claim before the claim's bar date, that the dollar amount on their claim controls. Section 3.4. I don't see 3.4 used that much, but 3.4 is to avoid judicial liens or non-possessory, non-purchase money security interests. What would be a non-possessory, non-purchase money security interest? Be like a lien on a bank account, or a lien on your paycheck from a payday loan, or a judicial lien, like a lien created by a judgment. If there are none, click none. This section, the math is a little tricky, but you do need to list the name of the creditor, the collateral, identify the nature of the lien, and then the amount of the lien, other liens. If it impairs an exemption, list the exemption here in Part C. Then you add it all up, subtract out the value of the property, and you should end up with a negative number, which means that the lien impairs the exemption and you can avoid the judicial lien. It's kind of similar to if you do Chapter 7, motions to avoid liens. It's just they do it in chart form instead of motion form. And I would note this section doesn't have an exception for governmental liens. So if it is a judicial lien by a state entity, like the Illinois Department of Revenue often files liens, there's no judicial lien exception in 3.4. Section 3.5, surrender. You bought a car, you want to give it up, or anything, furniture, bicycle, motorcycle. 3.5 is for any creditor that is to be surrendered to the secured creditor. If none, check none. Under this form of the model plan, the stay modifies as to the debtor and the co-debtor when the plan is confirmed. So if you put a vehicle or any other collateral in section 3.5, once the plan is confirmed, the stay terminates and the creditor is free to go and collect their collateral. And 3.5 also specifically allows that creditor to file an unsecured claim after disposing of the collateral. So you want to keep in the back of your mind or in the back of the debtor's mind that after the collateral is repossessed and disposed of, there is a possibility the creditor is still going to come back for an unsecured deficiency claim. Moving on to part 4 of the plan, moving away from secured claims to discuss priority claims. And attorney's fees not really priority claims under the code, but they're treated as priority claims in the plan. But since you're dealing with pro se debtors, probably won't be an issue. But in part 4, you have section 4.1, which is trustee fees. Section 4.1 are priority claims and trustees fees to be paid in full, except for claims treated in 4.5, and we'll get there in a second. For 4.2, you got to estimate the trustee fees, which is a best guess. Most attorneys use 10% when they're estimating trustee fees. It's a little high, but it's easy number. Right now, Marilyn Marshall's office, our trustee fees are 5%. Glenn Stern's trustees are 4.5%. I'm not sure what the fees are at Mr. Vaughn's office, but yeah, you do need to estimate that and do the math because it will help determine feasibility. 4.3, attorney fees, probably 0 because you're dealing with a pro se. And section 4.4, estimated priority claims, which would be priority debts due to the IRS, the Illinois Department of Revenue, and child support, which is not included in section 4.5. Timely filed claims control. So no matter what you put in 4.4, it's an estimate. Whatever's in the claim is going to control. So the trickiest part of section 4 is domestic support obligations owed to the state. Section 1322A4 of the plan allows that if the domestic support obligation is owed to a government entity, it can be paid less than 100% if the plan is proposed at 60 months. It is not for child support that is owed to a custodial parent. It is not for child support owed a former spouse. It is for support that is owed to the state. And that kind of scenario would be, say the child has aged out of child support, but the custodial parent received governmental aid. So the state is trying to recoup the governmental aid they paid by collecting past due child support. That would be specifically owed to the state. And that is the only kind of domestic support obligation that can be paid at less than 100%. Again, if it's none, click none. If there is a domestic support obligation owed to the state, list the state entity and the amount or portion of the claim that is to be paid during the plan. Keep in mind, anything you don't pay in the plan is non-dischargeable. So just because they're only paying half of what they owe the state of Illinois doesn't mean that they're not going to have to pay the other half as soon as the case is over. Pause. This is the MCLE code. If anybody needs it, y'all might want to write it down. We are getting a credit for this course. Let me take some tea. All right, everybody got it? And there'll be another slide later on that has the code again if you didn't get it this time. Continuing on, part 5 of the plan is the summaries, where you're going to wrap up how much is being committed to general unsecured creditors. There's 3 different ways you can calculate the amount being committed to unsecured creditors. 1, you can do a lump sum to general unsecured creditors. Lump sum usually only applies when the debtor is over median, and the means test specifies a minimum amount that needs to be paid to general unsecured creditors. That is probably the only time that the lump sum number would be appropriate. Or check the second box, provide a percentage to unsecured creditors. And you kind of have to complete the whole rest of the plan first and see what's left over and see what you can offer in terms of percentage to unsecured creditors. Most plans offer a minimum of 10% to unsecured creditors. I've seen plans as low as 1% if that's your best effort and that's all the money that you have available. It's convertible if it's feasible, but it has to be a fair distribution to unsecured creditors. So if you're going to do percentage, check the second box and just estimate based on their schedule E and F. If it's going to be 10%, round how much is 10% of their general unsecured claims. This third box almost always needs to be checked, which is the funds remaining after disbursements have been made to all other creditors. So if it's a 10% plan, but trustee disbursements hit 10% before the plan term is run, there's still money coming in for the balance of the 36 months. And checking this third box allows the trustee to continue dispersing over the 36-month term. And this tricky little line down here is what is referred to as the hanging paragraph. The hanging paragraph refers to the Chapter 7 liquidation amount. If the debtor's estate was liquidated under Chapter 7, how much would non-priority unsecured claims be paid? So in doing a Chapter 7 liquidation analysis, if there is equity, this is the minimum amount that unsecured creditors must receive in the plan. And regardless of the options checked above, this number controls. So you can propose a 10% plan, but if you have $50,000 in equity, and it says that if the estate were liquidated, there'd be approximately $50,000 available, that is what the trustee is going to pay to general unsecured creditors. It's referred to as the hanging paragraph, and the hanging paragraph controls. So you want to make sure that whatever you're proposing, either a lump sum or percentage, that it exceeds the Chapter 7 liquidation amount or exceeds whatever number goes into this line. I hope that made sense. Section 5.2. It's new to the National Model Plan. It is for long-term unsecured debt. It's most often used for long-term student loans, where you have a debtor with just an enormous amount of student loans that no percentage of the student loans would render a plan feasible, and they just want to address their student loans on their own. It's allowed pursuant to 1325B5. It's for when the debtor wants to maintain a contractual relationship on a long-term unsecured debt. And a lot of times, student loans are in deferment, and so they don't want the trustee to pay on any student loan claims because it's in deferment. They're non-dischargeable. Debtor wants to deal with the student loans after they've completed the plan. You can list it here. Just make sure under name of creditor, each line you list an individual student loan holder, whether it be Sally Mae, U.S. Department of Ed, Navient, whomever. What the current installment payment is. If it's zero, because the student loan is in deferment, just fill out zero. Or if they're on some income-based payment plan where it's a very low amount, just fill in what the current installments are. Who's dispersing it? Most likely the debtor. Is there an arrears to be paid? Not usually when it comes to unsecured debt. And the estimated total to be paid by the trustee, which is usually zero. The thing with the maintenance of non-priority unsecured claims is you want to watch for unfair discrimination. No unsecured creditor can be paid more than the other unsecured creditor. So if you're only paying 1% to all of your other creditors, you can't pay more than 1% to your student loans that you put here. A lot of times I'll see people say, I'm almost done paying my student loans. I'm going to pay it 100%. So this is my monthly payment on my student loans. Like, no, that's unfair discrimination. You can't pay one creditor 100% and pay everybody else 1%. And make sure to check the box for who pays, because if the debtor intends on paying, you don't want the trustee to start dispersing and have that money go into the ether. And 5.2, long-term, unsecured, non-priority debt. 5.3, separately classified unsecured claims. This is where you throw out what I said about unfair discrimination. You can pay more or differently to a general unsecured creditor if you have a valid reason. The most valid reason being a co-signed debt. The debtor co-signed for a credit card with her mother, and she doesn't want her mother to be stuck with the liability. That would be a valid reason to have a separately classified unsecured claim, and that would be a valid reason to pay that separately classified unsecured claim more than all of the other unsecured claims. And that's pursuant to section 1322B1 of the plan. So you can't just put in like Chase because you like Chase and they give you great points, so you want to pay them 100%. It has to be a valid reason, like protecting a cosigner, in order to pay one unsecured creditor more than the other. Leases. People often forget this section. Again, if there's none, just check none. But leases can include real estate, where you're living right now, your apartment. It can be leased furniture. It can be a leased storage facility. Any lease that the debtor has. You want to make sure they list it in section 6.1. If it's none, check none. If they do have a lease, and this is the reason why it's really important, if they're delinquent on a lease, like say they're behind in their rent payments, it has to be treated in section 6.1. The debtor needs to either assume the lease, like I'm going to continue to be obligated under the lease, or reject the lease. And it gives them an opportunity to break the lease and get out of any long-term obligations by rejecting the lease. It's for unexpired leases only. So if it's a landlord, it's your current landlord. So if you're going to assume the lease, check the box. If there are none, check none. You want to put the name of the creditor as your landlord, the description of the leased property, current installment payments. I have seen plans where the trustee makes the current installment payments under the lease. It's up to the debtor who wants to make them. Usually they want to keep making their lease payments on their own. The amount of arrearage to be paid, and then the treatment of the arrearage. So if you are behind on your lease and you would like the trustee to disperse on the arrearages to your landlord, you need to fill in this section right here. And it really helps because sometimes landlords file proof of claims and the trustee doesn't know what to do with them. And it can cause feasibility problems in the plan too. And if the lease is current, you still fill it in and just put 0 for the arrearage. But you do want to assume any unexpired leases. The last sections of the plan, 7.1 and 8.1. 7.1, when will the property vest? When does the property of the estate become the debtor's property again? You have to check one. Does it vest at plan confirmation or does it vest at entry of the discharge? Used to be standard, every single case was entry of the discharge. And I don't know if anybody's been following the City of Chicago parking ticket cases and the Seventh Circuit and the Supreme Court opinions and all of that. The City of Chicago is probably the only person who will object to plan treatment in section 7.1. They want property to vest at plan confirmation so that if the debtor gets post confirmation liabilities, parking tickets, that sort of thing, they can enforce it against the collateral. If property vests at the entry of discharge, it stays property of the estate until discharge. It stays protected under the automatic stay. But the Seventh Circuit has said, and the code has said, it's a choice, and it's a choice that the debtor has to make. So it's not automatic, check a box. Other is available for a case where the debtor isn't eligible for a discharge, but you still want it to remain property of the estate for the term of the plan. You can check other and say, property will vest upon case closing, or property will vest upon making the last plan payment. So that would be what the other is for. 8.1, non-standard plan provisions. Anything that didn't get swept up in all of the other sections, this is where you want to put it. One thing that's not provided for in the plan that most unsecured or secured creditors want is adequate protection payments. Cars want to start receiving monthly payments from the trustee even before the plan gets confirmed, especially with pro ses. Sometimes it will take months for a plan to get confirmed. So they want a fair, adequate protection payment, which represents something equivalent to depreciation. So you can offer Santander finance $100 a month until the plan gets confirmed, so that they are receiving some money to protect their interest in the collateral. And surprisingly, that's nowhere else in the plan. So you can put that in section 8.1, and it's equivalent to the cost for use of the estate property. Any pre-confirmation payments you want to make, but pre-confirmation payments are really only for purchase money security interest creditors. Cook County doesn't get pre-confirmation payments for their real estate taxes, or City of Chicago for their parking tickets. It really is for purchase money security interest creditors only. Another thing that often 8.1 is used for is to provide for interest to general unsecured creditors in limited cases where there is a lot of equity in the estate. Unsecured creditors deserve to be paid a certain amount of interest on their claims. And so if that is the situation, that would also go in section 8.1. But anything additional that you feel needs to be written, said, it goes in 8.1. If it's none, it's none. And note again, it has a reference to section 1. The following provisions will be effective only if there is a check in the box included in section 1.3. So tackling the plan. Like I said from the top, first you have to find out what the debtor's motivation is. What is most important to them? What do you have to make sure is provided for in the plan, and what could maybe be let go? So the first thing you want to find out is, are there any secured claims? So in the order of operations, in terms of tackling a plan, you want to do part 3 first. And part 3 should be based on the debtor's Schedule D, which lists all of their secured claims, but it also, you need to check the claims register and see if any secured claims were filed that the debtor hasn't provided for. Maybe they didn't realize was a secured claim, didn't realize was still out there. If it's a home and it's mortgage arrears, address the mortgage arrears first. Fill out that line completely and make sure there's enough money to cover the mortgage arrears. Address how much needs to go to any creditors secured by vehicles. That would be second. I think maybe their car is more important. I would do mortgage arrears first and then the vehicles second. So now you know how much a month you need to pay the mortgage arrears, and you know how much a month you need to pay fixed set payments to the vehicles. And then you also want to go over any past due real estate taxes. I've seen a lot of cases, especially in Cook County, where there's claims for past due real estate taxes, tax liens from the IRS or the Illinois Department of Revenue, etc. So part 3 is really where you want to bite into the plan first. And while you're going over that part 3 with the debtor, you want to find out what is necessary. What is necessary for them to keep? What is necessary to be paid in the plan? If they've got 2 cars and a Harley, they're probably not all necessary. And the trustee will object to paying for 2 cars and a Harley while paying 1% to unsecured creditors. So you really want to try and make it fair and balanced. So that's the first thing you need to tackle, is what is necessary and what set payments are required to satisfy the secured claims, the stuff that is really important to the debtor and what they really want to keep. Next is what must be paid. And what must be paid are the priority claims. Debtors should have an estimated priority amount on Schedule EF. If they schedule the IRS or the Illinois Department of Revenue as a creditor, they should have a guess as to how much is owed. So you want to put that estimated amount in part 4 and also check the claims register. Pursuant to 1322A2, priority claims must be paid in full. So that's something that can really blow up a plan if someone doesn't know how much they actually owe the IRS, or if the IRS files a claim significantly higher than what the debtor thinks they owe. Trustees fees, like I said, most people just use a rule of thumb as 10% to do the math. So you've done part 3 and you've done part 4. You filled in all the must-haves and the must-paid. And what remains for the general unsecured creditors? And like I said earlier, the trustee usually requires a reasonable distribution, which I think is best effort. But a rule of thumb is 10%. It must meet the Chapter 7 liquidation amount. Unsecured creditors must be paid at least what they'd receive if the debtor's assets were sold in a Chapter 7. And that's important, if the assets were sold in a Chapter 7. So, keep in mind, Chapter 7 trustee, he gets a little fee. And so what would be left if this were a 7 and the property was sold, not just the face equity. And if the debtor is over median, what remains for general unsecured creditors must meet the minimum dollar amount dictated by the means test, which is the Form 122C2, which by the time you're preparing the plan, the debtor has already done their 122C2 form. Is there enough money? And that's a good final question. I actually, when I'm reviewing plans prior to confirmation, I do the math by hand. So this is kind of how I do the math. You take the plan payment and you multiply it by the number of months that the debtor's proposing the plan, whether it be 36 or 60 months, and then multiply it by 0.95, which will take the trustee fee out. And then from that number, subtract the must-haves, the estimated secured claims that are supposed to be paid by the trustee, and then subtract out the priority claims that need to be paid at 100%. And that dollar amount you have left is what is left for general unsecured creditors. And hopefully, if everything's done right, that is a positive number. And you actually have, 1%, 10%, 50% available to unsecured creditors. And you get the percent by, taking what is left and dividing it by the total estimated unsecured claims. So that's how I calculate the percentage that is going to be paid to general unsecured creditors. It's worth noting, if you don't end up with a positive number and there's not enough money being paid into the plan to allow some distribution to unsecured creditors, you may have to go back and consider reviewing Schedule I and J with the debtor to see if there's any unnecessary expenses on Schedule I and J or any expenses that can be minimized. If there isn't, and there just isn't enough money, then the debtor may need to consider either surrendering something that they thought they might really want to keep, or consider converting it to Chapter 7. Final review of the plan. After verifying that the math works, then you've got to go back and check all the appropriate boxes. So you want to make sure that all the appropriate boxes are checked in Part 1, that notice section that we talked about at the top. For Part 2, make a plan payment for a specific term that's feasible. The plan payment should match what is available on debtor's Schedule I and J. So if a debtor has done their budget and they have $600 a month available on Schedule I and J, plan payment should be $600 a month. It can't be $200, it can't be $1,200. It's got to match what the debtor has available, unless it's 100% plan. If it's 100% plan, you can pay a little less than everything you have available. But in most cases, the plan payment should match what's available on I and J. Again, the term, 36 months, unless the debtor is over median on their means test, which would make it a minimum 60-month term. Be sure to check a box in 2.2 for payroll control or direct payment. Section 2.3 for tax returns. And like I said, the trustee has standard language on their website for refunds or returns. And if they have estimated future tax refunds on Schedule I, just provide that they turn over their returns to the trustee every year, and advise them that if they don't turn over their returns to the trustee every year, they'll get a motion to dismiss. It's required by the plan and all the trustees. I already went over the vesting issue a little bit. In Ray Steens is a Seventh Circuit case that I referred to earlier. Debtor has to have a good reason to have the property vest at discharge. The judges don't take a position on that. The trustee doesn't take a position on that. It's entirely up to the debtor. The only person that ever files objections is the city of Chicago for section 7.1. I mean, for now, that may change in the future, but that is right now. And then again, section 8.1, all creditors need to be treated in the plan itself. Don't, like, if the debtor doesn't want their student loans paid in the plan, put it in the proper section of the plan. Section 8.1 shouldn't have any specific language about treatment of creditors. Like, it shouldn't say, don't pay Toyota Motor Credit because my sister's gonna pay it. Put it in the proper section of the plan. And also some creditors do file objections requesting that there be lien retention language in 8.1. So we want to add that when necessary. Oh, and we're to the second code page. So that wraps up what I've put together. And I know it's a blast through the plan, and it's just a basic overview of, you know, what to look for and how to advise debtors. But does anybody have any specific questions?
Yeah, we're at the end, Yannick, but we have a few more minutes. And I think there's one question in the chat.
Okay.
Denny, did you see that?
Yes. So we have a question here, and it asks, what if the debtor doesn't have consistent income? How do you figure that if they earn tips, for example?
Best estimate, an average. The debtor prior to the 341 meeting is required to provide the trustee with proof of income, proof of their last 60 days of income. But cash tips don't show up there. A lot of times as proof of income, we'll accept an affidavit that refers to what their average tips are, or maybe a list that says, you know, the first week of February, these were my tips. The second week of February, these are my tips. And then you sign it as an affidavit under penalty of perjury. Just evidence, some sort of evidence. And then when you're sitting down with the debtor to do the budget or the plan, I always ask a debtor, what can you reasonably count on? You don't want to overestimate and get them in a tough spot, but you want to make it fair. So you just have to estimate a fair amount.
Okay, great. It looks like we have another question. How is the trustee treating the CARES Act mortgage forbearances? For example, if the debtor files and is currently in a forbearance and wants to maintain the status quo.
We're not. We're not taking any action when a CARES Act forbearance notice is filed on the docket. We're still going to pay the arrears claim as provided for in the plan, and we don't like file a motion because, oh, now I know the debtor's not making their mortgage payments. No, we don't do anything. We just make note.
Okay, great. It looks like we have another question. It says, how do you treat stimulus payments and overtime and bonuses?
Stimulus payments are specifically exempted from the disposable income calculation. So we don't ask about stimulus payments. We don't take stimulus payments. Bonuses, depending on how often they receive the bonus and if it's regular and reliable, you can either prorate it on Schedule I. If you know you're going to get a $10,000 bonus every year, divide it by 12 and put a bonus line on Schedule I. Or the plan can provide in that Section 3 under other payments, it can provide for the debtor to make a lump sum payment to the trustee at the time of their bonus, but the bonus does need to be addressed in some way. We usually notice them when we're reviewing pay stubs, and we ask that that be addressed. In terms of overtime, I would go back to the same answer with the tips, best estimate of what is reasonably expected and reasonably reliable.
Okay, so now we have another question about So it says for debtors with limited, or no use of technology, what should we advise them in reference to the 341 meeting?
That's tricky because I know that both trustees in Chicago are doing the 341 meetings, at least in part via Zoom. So it's expected that you have the ability to get online somehow. A lot of times, especially with older debtors, I suggest that if they have a niece, nephew, granddaughter that has a iPhone and can come over for 15 minutes to help out, or I've seen people go to the library. I don't necessarily recommend that in the time of pandemic, but it, really, we've always found a way with pro se debtors and with even debtors that are represented that may struggle. We always find a way to get them online. So just, give them all the tips and tricks you can as to where technology may be available to them.
Okay, let's see. Do we have any other last questions that anybody would like to drop in the chat? Okay.
No, looks like not. So otherwise, thank you, Yannick, so much for a very informative session. And of course, the materials are available to everybody. And we all look forward, hopefully, to seeing everyone next week for our final session, which will be on sort of the potpourri, the smorgasbord of post-filing issues that arise and that debtors come to the help desk with help for. And Sal Lopez and Judge David Cleary will both be leading us next week. So that'll be, look forward to that. In the meantime, thank you and goodbye. Stay safe.
Thank you, everyone.